good evening to all. Today we are going to discuss all the possibilities of litigation against the practicing doctors. We have to categorize things in a way so that we can understand in a better way eventually the less number of litigation, and even if the litigation happens, we have to handle that in a proper way, in a legal manner. We will try to focus today in the scenarios where, as a practicing doctor, we are caught under the purview of law and how we can manage our escape route from that kind of legal scenario. So it's a broad topic. It is the liability of doctors. Until said otherwise, we are trying to say it is the legal liability of doctors. There are many other liabilities can possible. It's a liability to the society, liability to the hospital authority, etc., etc. But we will concentrate only liability where doctors are liable to the law. It could be single law or it could be multiple law simultaneously or as well as separately. So to start with, we need to understand that in today's scenario, every patient, every possible patient party or their relatives can lead us or drag us to the law of court. It may be rational, may not be rational, may be justified, may not be justified. We cannot stop anybody going to any of the legal authority or court. India do not have any kind of legal bindings that one patient cannot drag me down to the court. So if we try to understand the scenarios in recent last 10 to 15 years, we will see since the 1950 to 2010, it's the graph is showing is for up to 2010, but 10 to 20 is not the different, it's the same. If you can see the education awareness, it is increased, quality of healthcare also increased, but at the same time dissatisfaction against healthcare is also increasing. It is more or less in a proportionate manner. If we consider that educated guys and the healthcare facilities if improved, the litigation will go down. The real life scenario is not saying the same picture. It says it is almost equivalent to what was in 1950, and at the same time we are today in 2022. If we come to focus in Indian perspective, we will see that 110% yearly rise in India. It is the statistics of the last 6 to 7 years. 90% of the litigations involves hospital and 65% related to consent and documentation. As all of us are primarily surgeon, so that is a very important area for us to understand the consent and documentation. In our last session regarding the surgical consent or informed consent, we have discussed a lot of things related to surgical consent and documentation. Today we will discuss the overall legal scenario where doctors are liable, and more specifically for the CPA, and what are the reasons why most of the cases ultimately leads to CPA. If we have a graph of dissatisfaction, grievance, and actual complaint, it will enumerate in a way that most of the patients are not satisfied, that is dissatisfied, because it is very difficult to, in the service segment where the expectation rate is very high and our infrastructural and expertise capability is not keeping pace in that time frame and in the mindset of the common people. So dissatisfaction is enormous. A small section of this dissatisfaction comes with the grievances. It may be they are communicating this to their peer colleague, relatives, or even the hospital authority, but ultimately they are not going to the law of court. Few of these grievances actually goes to the actual complaint and litigations. So our focus is that rate portion of this triangle, actual complaints and litigations. Though there is a paradox, genuine negligence cases are really reaches to the court. That is also true. I am not saying that doctors are never negligent, they cannot commit mistakes, not like that. If we all are human being, we are trying to do something good to the society, to the particular patient. So mistakes are there, but all mistakes are not the negligence. Mistakes can happen, but negligence is a completely different thing. We will try to understand the negligence first, because every legal aspect is based on a one single term, that is negligence. At the same time, one patient or one negligent case can be tried in different forum. So if we consider the CPA and the medical council, we will see almost 95% overlap of the CPA and the medical council cases. So if you are caught in a CPA or negligence case, then most likely you are 95% probability that you will be also caught by the MCI. Now it is NMC, National Medical Council. So most of the litigations are basically completely frivolous, just to extort money or to teach the doctor a lesson. The statistics shows that it is almost 80%. Justifiable cases, yes, there are justifiable cases, is almost 20%. And these 20% cases, there are two sections. One is defensible, and there is one small pie of it that possibly not preventable. Say, for example, you have operated in the wrong limb, complain in the left eye, you are supposed to do cataract operation on the left side, but you have done it on the right side. So it is probably not preventable or not defensible. But most of the situation, it is defensible. In case of frivolous cases, which is the larger pie, it is preventable. Only few is very difficult to defend because we do not maintain our documentation, and there are few unrelated bias and cases. Say, for example, one patient came from your chamber and going to the straight to the police station, and he or she is saying, if it is girl, it's more common that I was molested in the clinic. So there is no law that a female is getting stopped to go to the police station. So you are caught in a sexual harassment cases in your clinic while you are doing your professional work. So these are the scenarios. So we will try to understand the dynamics to prevent this kind of scenario. And if at least it happens, we have to prepare ourselves in a preemptive connection, that so that we can defend or we can prevent this in the litigation or in the court. So we have to do our practice in a safe way. This safe practice in surgical industry is, we are all getting trained how to do safe surgery. But I am trying to emphasize on the scenarios, which means how to do the safe practice. It is other skills than the surgery per se. Liability of medical professions, you can lead to any of the forums in the left hand side. It's starting from the consumer forum, civil court, criminal court, medical council, Ministry of Health and Family Welfare, Human Rights Commission. In case of West Bengal, there is one entity called CRC, and there are many other specific things, just like PCPNDT and THOA, Media and Public, Hospital Authority, Global Social Elites, etc., etc. Before going to the concept that you and me as a doctor, we are first the citizen of India. So we have liability as every other citizen do have in India, but as a professional, we have liability to many of the institutions of our society, namely government. It is the government, state government, or the central government. Authority means under which banner we do work. It is usually means the hospital, and the patient for the direct patient care. So we are, when we say the liability of medical professional, usually we mean professional medical liability towards the patient. Usually we skip this government and authority liability or liability as a common citizen. Say for example, being a doctor, you are driving a car but violating the basic traffic rules, so you will be caught just like another citizen. So you cannot avoid the liability of a citizen of India. On top of that comes the professional liability. It is the government directed, authority directed, and last but not the least, it is the patient directed, what we are focusing in our today's discussion. Say, for example, we have seen the governmental issues and liability as a doctor in case of COVID, because it's a pandemic disorder and we have a specific set of laws to deal with this kind of situation. So we are also liable to the government. Almost all the doctors felt this scenario in their lifetime. Possibly you and me won't come across this kind of situation before this COVID pandemic. So today's discussion will be professional medical service towards the patient, not we are discussing the government liability or liability to the authority. One common example is, say for example, you are trying to go to one of the relatives' marriage ceremony. So you applied for leave to your HOD or head of the institution, medical superintendent, whoever he or she is, but it is getting denied. So it's a liability to comply with that denial. If they approves it, then you may go. So it is the liability towards the hospital authority where you and me work as a doctor. So liability is nothing to do with a legal term. It came from the financial world. It means the legal responsibility of one's acts or omission. Though we commonly use in the legal scenario and particularly in healthcare issue or healthcare world, but the exact terminology of liability came actually from the financial world. Doctors can be liable both in the civil and criminal law, and ultimate it will be decided by the court, not by you and me. So court will decide on the basis of the facts and figures what is shown to the court. So we are trying to deal with the professional liability towards the patient, not exactly towards the government or towards the authority in this today's discussion. We have to respect the 17 rights of patients, which is mentioned in the Charter of Patient Rights. It is, you can go through it, it is available in the website of Ministry of Health and Family Welfare. It is clubbing together all rights. It's a human rights, constitutional rights, rights under various kind of laws and other things. It is enumerated the 17 rights in India patients do have. We as a doctor, we cannot violate any of the rights of in any individual patients. If we violate any rights, then it will be one sort of breach of duty or negligence. There are three terminologies in this whole scenario: breach of duty, reasonable care, and negligence. We have to understand the clinical basis of this legal interpretation, because whatever we are doing, it is doing as a doctor. It's a clinical setup, but whoever will be judging whether you or me have done the right thing or not, it's the legal scenario. So we need to understand how this legal world interprets all these things. That is the basic. If somebody can prove you negligent, so you probably most likely will be penalized in all the forum. If nobody can prove you negligent, then probably none of the forums will be able to punish you. So understanding negligence is the first and foremost thing to understand the legal liability under various kind of law and various kind of legal situation. The first thing is the duty of care. We have to understand duty of care includes both the medical care as well as the legal care. We have three specific things. First is the decision making, whether I am going to take this patient or not to take this patient. Say we all are surgeons. So far I know some gynecological patients came to you. Now it is your decision that whether you will take this patient under your care or not. Say for somebody came to you with a lump and ultimately it was diagnosed as a uterine fibroid. So if you take this decision, yes, most of the surgeons will be able to do a hysterectomy, but probably that is not under your curriculum. So if you take the decision to take this patient and if anything goes wrong, then definitely this decision is questionable. Being a surgeon, you have taken a decision to take a patient who requires hysterectomy, for which possibly you are not well trained, because MS curriculum, it doesn't include the hysterectomy. So decision making, it is the first stage of duty of care. Next is the diagnosis and treatment. So whoever is the patient, next responsibility, if you take this patient under your care, you have to diagnose and advise treatment. There is a catch. It is not only the advice treatment, it is also the administration of the treatment. That means as a consultant, if you work in a hospital, definitely you are not available round the clock. Some of your juniors are treating throughout the clock. So if any junior makes a mistake, it also comes under your liability, because administration of treatment is also your liability. So we have three specific things: decision making, whether I am taking this patient or not, it is the first duty. Second duty is the diagnosis and advice of the treatment. It has to be correct as per medical opinion. And third, administration of the treatment, that also has to be correct in a medical world. So this chronology is same and similar in each and every disease specification or each and every doctor patient scenario. So this constitutes the duty of care. Be specific. So it has two different quotient. One is the quality quotient and another is the legal quotient. We have to understand duty of care includes both the legal quotient and quality quotient. If you have maintained these two quotient in a perfect manner, then it will be termed as reasonable care. So reasonable care is the terminology which means medical care and legal care is adequate, so that nobody will be able to see that duty of care was deficient. So if any of the legal quotient or quality quotient in a medical treatment is deficient, then reasonable care is not there. So you have to understand and consider both the quality and the legal quotient of any particular doctor patient scenario or any disease scenario. Now comes to the negligence. So we know the duty. So we have a legal duty. If any breach of that duty, then that breach should cause the actual injury to the patient and damages from that injury. That means that injury resulting some kind of expenditure or some kind of things which have a money equivalence. Damage and damages are not the same thing, though in our day-to-day practice we do coin these two terms synonymously, but damages means the money equivalence of any specific thing. That is called damages under the law. I will try to differentiate this damage and damages in the whole presentation, but if I somehow mix this, just make it a very clear concept. Damages in legal industry means money equivalence of something. So this all four established, that means negligence proved, existence of legal duty, any breach of that duty, that breach caused some injury, and that injury incurred some kind of financial involvement. If this chronology or this sequence is satisfied, that means negligence is proved. So our first consideration should be, we should not do something where all these four scenarios to be satisfied under the court of law. If the negligence is proved, then It can go to the human rights. There will be recommendatory actions. You may be awarded compensation in the CPA and civil laws, and Human Rights Commission, Ministry of Health and Family Welfare, in case of West Bengal, CERC. And temporary or permanent deregistration is possible from the Medical Council. And if it's criminal law, then jail or fine is also possible, though it's not very common, because criminality of medical negligence is something different ball game, and it's not so easy to actually prove there is a criminal liability of doctors. But be specific, you have civil liability as well as the criminal liability if these four can be connected from the whole scenario. Whoever is filing a case, their lawyer will try to connect these four dots. Our aim should be, we should prevent ourselves and to do something where these connecting dots are very easy. It should not be easy, and that is how we should handle these things. So to prove negligence, we have to prove this sequence: duty, there is some breach, there is some injury, and ultimately damages. So duty is the professional responsibility of doctor to his patient, which is legally bound. It's very important, and there should be standard of care and duration, and whatever we are doing, it has to be acceptable. It should not be very poor, or it may or may not be excellent. Nobody will penalize you for not being excellent surgeon, but everybody will penalize you for being some surgeon. Whatever method you have adopted, that is not acceptable by even your peer colleagues. So it is fair, just, adequate, and most will do in that particular given situations. And that is the medical component, and that is one legal component is always there. There should not be any violation of law and ethics. If you can satisfy these two, it will termed as reasonable care. And if you can establish a reasonable care in any legal scenario, that means you are not negligent. Now come to the next stage. What is the breach? Duty of care constitutes decision making to take or not take the patient, diagnosis and formulating the treatment, and administration of the treatment which is acceptable in the peer colleague group. Whenever a patient comes to you or me, duty starts. If I say that I am refusing this patient or not, I am not taking this patient, my duty ends there. If the patient comes, the duty to whom? It is direct to the patient. This is number one. If sent by the authority, then the authority first and the patient second. Say, for example, somebody caught by the police, and police officer sent the patient for a basic physical examination. So now patient is Mr. X, but your liability as a doctor is to the police first, then the patient. This situation is constant until and unless there is life-saving emergency in this patient. Otherwise, authority is the first entity where as a doctor we are liable. Sent by third party, it is in most of the scenario corporate health checkup, or there are many insurance checkup, visa requirements, etc., etc. Then the whoever is sending patient to you, your liability is first to that third party. Here is the same situation until and unless there is a life-saving emergency of the patient. Due to the government or authority, say for example, informing communicable disease, informing birth, informing death. Birth possibly you will not be able to encounter because you are not gynecologist, but death definitely you have to encounter. And usually you do not write the information toward the municipality or panchayat. It is done by the hospital authority. So primarily responsibility is to inform the government entities. In any emergency of any situation, it is the patient first. So this is the conceptual framework whom I am liable as a doctor. There is a one very interesting scenario when this duty is actually ends. Recovery of the patient, say for example, you have done a lab chole, patient is fine, discharged, you asked to review by 2 weeks time with the histopathology, you have seen the patient is fine. Now most of us do not understand how to stop the duty. We never mention that this duty stops here. If this patient comes with a port hernia, whether your duty will be continuing in that phase, say for example, I am talking about 3 years down the line, the answer is, it is how you write your prescription in post-op follow-up. You have to deliberately write something to establish duty ends there. One tagline I always suggest, for this regard, you do not need any further follow-up. It means if you have done the lab chole, post-operatively you have seen histopathology, it's a non-malignant, now you are stopping your duty by saying, do not need further follow-up regarding this lab chole, or whatever way you want to frame it. But if this patient is having a hernia or something else, it won't include in your statement. That means you are stopping this duty of care of doing lab chole. But unfortunately, most of us do not write something in that way. They verbally said, okay, आपको और आने का जरूरत नहीं है, you should be fine. But that means you are not stopping your duty at that point of time. So try to build a practice of stopping any specific duty. One patient has done lab chole, he cannot make or arrange follow-up for rest of his life. It is not possible. So you have to stop somewhere. It is your primary responsibility where to stop. Patient abandons from treatment, then definitely duty stops. Patient taking treatment from another without informing, you can stop it. Patient not following your treatment, death of the doctor, or patient handed over to another doctor, so your duties ends that point of time. So we have to write something to stop the duty at some point of time. Any deviation is breach. It can have medical component and as well as the legal component. We do understand medical component. Legal component is an ethical or legal violation to the patient or to the authority. Now if the catch, it is the injury. Whatever we do in surgery, every time there is some kind of injury, but how law interprets it, it is defined in section 44 IPC, Indian Penal Code. Any harm whatsoever illegally caused to a person in body, mind, reputation, and property. We deal with body. So in our scenario, it's the body, not mind, reputation, and property. Illegally, we have done it legally, the consent is there. So it is illegal, but we are doing injury. But what exactly mean? It is caused by breach of duty of reasonable care. If we do not provide the reasonable care and that causes injury, yes, there is a situation what we need to understand. One patient can go to the court and ultimately he or she will try to draw attention that there was some kind of breach of duty followed by some kind of injury. So in our situation, it is the physical, mental, and financial loss or burden to the patient. And whatever is the money equivalence, that is called damages. Sorry, it is a spelling mistake. It's damage written here, but it should be damages. And before calculating or considering whole scenario, forcibility and proximity clause will be there. So what are the physical scenario or physical injury, pain, disability, mental, stress, fear, loss of amenities, and financial, whatever expenditure incurred. It is in the various form, medical expenditure, future medical expenditure, earning loss already happened, future earning loss. So all these will be calculated. So negligence, we need to prevent the probability of proving negligence. So this is the flow chart. If it is a civil kind of thing, it will be compensatory, regulatory, or recommendatory. But if it is a criminal liability, then it could be jail, fine, or both. In civil scenario, we do consider it is the careless approach. In criminal scenario, we do consider it a reckless approach. So we have to be careful. Only then we can basically put many blocks in this flow chain, in this flow of events. If we can block in a proper way, then nobody will be able to prove negligence. If negligence is not being proved, then no forum can penalize the doctor. So compensation calculation is a complex mechanism. Try to understand whatever actual cost and whatever future actual cost, and there are many intangible costs, everything will be considered in the calculation of compensation. It could be phenomenal amount, phenomenal. We have discussed how we can take take measures to stop the directly or indirectly this financial liability, because both of us, you and me, are considering about the conscious about the financial liability. Because if it is few crores, it is very difficult for us to pay from the own pocket. Even the indemnity insurance highest slab is 2 crores, it can't be more than that. In VP Santa case, it is the first time in 1995 doctors and medical profession dragged into the ambit of the CPA, Consumer Protection Act. Most of the cases will lead to consumer protection because it is the only situation which is common, and patient and the relatives will get direct compensation in terms of money. Say for example, if you are pushed behind a bar, you are in jail, so what the patient party will get? They won't get anything. So most of the cases are basically to grab some amount of money from your pocket to the patient or the relative's pocket. So wherever this getting money is easier, the most of the cases will go directly to that forum. In this situation, we know that CPA is that forum where this getting money is little bit easier. That's why most of the cases will lead to the CPA, not in the criminal court. So money consideration is very important. We have to understand few consumer rights and how we are basically entangled with this. Consumer International is a global organization. They fight for the consumers, and they have designed the 8 situations or 8 rights of the consumers. Consumer International is a 250 nations or 250 organizations clubbing together formed throughout the globe. It is the Consumer International global agency. It represents in 120 countries. India is not an exception. And they have enumerated 8 rights that each and every consumer should have. In Indian law, we have recognized these 6: safety, choose, information, heard, consumer education, and redress. So this is enumerated in our Consumer Protection Act 1986, which is basically modified, and the current act is 2019 CPA 2019. Our discussion will be based on the recent Consumer Protection Act of 2019. So formulation of CCPA or Central Consumer Protection Authority, then the state level, then the district level. Most of the cases will go to the state level or district level. We do not need to memorize all the clauses. What we have to understand, if we can bypass this forum by mediation or arbitration, it will be favorable for doctors. So we have to inbuilt or incorporate mediation and arbitration clause in our consent form. Then one has to root through that mediation and conciliation or arbitration only thereafter they will be able to go to the consumer forum. Anything and everything can be ground of filing a case. We do not need to understand. Anybody can go to a consumer court and say something against you and me and file a case. There is nobody or no law is there to prevent them to going to the court. In healthcare scenario, patient, the relative, the NGOs, or even distant relatives, anybody can file the case on behalf of the patient. If the patient died, on behalf of the patient, their peer group, NGOs, relatives, etc., etc. So anybody can file a case, whatever may be the ground. So what exactly consumer in healthcare industry? Read it very carefully. You need to understand. Many times we do think if it is free case, that means it is not consumer case. It's not like that. Somebody, any person hires or avails any services for a consideration which has been paid, promised, or partly paid or partly promised. Only promise, not paying today. Promise of payment of 2 years later. This is situation. It means promised. Partly promised. Your fees is 10,000, 5,000 paid and 5,000 will pay 2,000 2 years down the line, 2 years in the future time. Under any system of deferred payment, anything. So payment, whether you are directly receiving the payment or not, it is not only the criteria that somebody cannot go to the CPA. And includes any beneficiary of such services. This includes all the family members, NGOs, etc., etc. Even buyers from e-commerce or teleshopping or MLM, everybody can go to a consumer court. Healthcare is a service under the Consumer Protection Act. It may or may not be paid. There was a famous case whether the ESI patients coming to a private hospital is a consumer or not. So ultimate ruling was, yes, they are consumer because ESI is ultimately paying to the hospital. It's not free. It's not absolutely free. Even the ESI patients treating in ESI hospital, that also comes under the Consumer Protection Act, because ESI charge a nominal amount of fees from the salaries of the employees. So it is also not free. So they are also under the act of CPA. So it is very difficult scenario to avoid or bypass the CPA. So consumer in healthcare, who pays or legal hires. This is the simplest form to be remembered. Practical scenario is anybody or everybody could be the consumer in healthcare. Anybody who complains, he is the complainant. What is the complaint? Any allegation in writing made by a complainant, it may be correct, may not be correct. That's a different ballgame that will be decided in the court, but it is a complaint with a view to obtaining any relief provided by or under this act. It is the clause that means somebody who is complaining, that means he is expecting some sort of remedy under the Consumer Protection Act. So complainant, anything and everything is the complaint is possible. When one patient can complain? Up to 2 years. First hearing should be by the date of 21 days. Reply to the complaint is within the 30 days, but this can be vary widely if the complainant can influence or convince the court that due to the COVID, I was not being able to come to the court. Then it can be accepted. In general, it is not there, but yes, it under the legal purview, this is possible. Whatever is the verdict, any of the parties they want to appeal, it should be done within 45 days. In 2019, there is one distinct difference from the previous CPS. District forum ranges up to 50 lakhs, state commission 50 lakhs to 2 crores, national commission is more than 2 crores. What is different? Considered value plus other value clubbing together, say if we consider the district forum, the considered value and other value, total valuation if less than 50 lakhs, then it will be tried under district forum. But in 2019 Act, there is one subtle change. It is the only considered value. Say there is a treatment cost of total under the consideration 50 lakhs, but mental agony, etc., there is another 10 lakhs. So total amount is 60 lakhs. It can be tried under district forum because considered value is 50 lakhs. It has to be up to 50 lakhs. So this is the one difference from the previous CPA to the 2019 CPA. There are very nominal fees. If it is less than 5 lakh, it's nil. Then 500, 800, 1000, and maximum is 7.5 thousand. If it is a case of 100 crore, even the fees is 7.5 thousand. So consumer, whatever verdict gives the consumer forum, remedies available, removal of the defect or deficiency of services. In case of healthcare, this is not possible. Replacement of good. In case of healthcare, it starts with the compensation, then mediation. If it is frivolous complaint, if you can prove this, the complaint is frivolous, then up to 25,000 fine will be imposed to the complainant. If any of both of the parties is failed to comply whatever the verdict of the consumer forum, it is punishable up with imprisonment maximum 3 years and fine maximum 1 lakh. So 3 years jail and 1 lakh fine is provided under the CPA if any of the parties fail to comply whatever the verdict given by the any of the forum. We don't need to go through the appeal. That is how this kind of situation we have to face in the consumer forum. There are many other liabilities of the doctors. It's a big topic. Today we discussed the CPA because it is the most common form where the patient and the relatives will go, because it is the quick money, and that is how we should be benefiting by having the knowledge so that we can adjust ourselves in a proper way. That's all for the today. If you have any question, feel free to ask me. Thank you very much.